prosecution did not bring, specifically not bring in the shooter or other people who could answer how he specifically got the gun. The answer is no, right?
Correct, Judge.
Do I need to refer them to, do I need to send them 2.9 or 3.5?
I believe you need to send them 3.2, Your Honor, because a reasonable doubt is defined as a fair, honest doubt growing out of the evidence or lack of evidence, and it appears they're asking about lack of evidence.
No, they're asking if they can fill in the blanks about why the shooter isn't there, aren't they?
Yeah. Yes.
Yeah, we can't let them fill in the blanks.
I agree with that, but I think it goes to, they're asking essentially why the shooter didn't testify or other witnesses, and the defense doesn't have a burden to put any on. So we believe it's important to remind the jury that the burden is on the people and that a reasonable doubt can come from lack of evidence.
Judge, again, we can't guess what they're thinking, we just answer the questions. I'm sorry, which instructions did you?
I was thinking, well, these are the preliminary instructions 2.9 and or 3.5, was it?
Oh, 2.9 I think would be appropriate here.
I'm sorry, 2.9 and what was the other?
3.5 maybe. I don't think it says. I can bring them in and read 2.9 and 3.5 to them if you want. Talks about evidence, including only sworn testimony, witnesses, exhibits admitted to evidence, or anything else I tell you consider as evidence.
It seems on point, Judge.
I have no objection to 2.9. I am just making a record that I'm also requesting 3.2.
Okay, wait, do you want 2.9 or 3.5? Either one of those. I'm trying to keep myself to answering the question that they asked. They have an instruction with them about reasonable doubt. They've heard it a bunch of times. They do not have in the jury room 2.9, although they do have 3.5. So,
Judge, the answer to the question is no, and I think reading 2.9 again and 3.5 probably appropriate given the question.
okay. That's what I'm going to do.
Thank you.
I'm going to bring them in now. Okay.
Thank you, Judge.
I'm sorry, what's that?
I'm going to bring them in. Can we infer anything from evidence of witnesses that the prosecution did not bring? The answer is no. And you say specifically not bring in the shooter or other people who could answer how he specifically got the gun. So I'm going to take you back to our first day of trial and read you this instruction that I read you on the first day. When it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. You also have a copy of 3.5, which I'm going to read to you. You don't have a copy of 2.9. That was read in the beginning of the trial. 3.5 says, when you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that she is charged with more than one crime is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. So I'm hoping that I helped you. All right? So I'll have you return to the jury room.
All rise for the jury.
You may be seated. The lawyer's approach on the issue I brought up previously.
Yes, sir.
All right.
All right.